Morning, everyone. Thank you for joining us again for Minnesota Matters. I'm Tess Rice, MBA's General Counsel. I'm joined by Teresa Kubas, our Senior Government Relations Manager, and Tom Boswell-Healy, Associate Counsel and Compliance Consultant. This will be recorded. All of these episodes are on the MBA's YouTube channel, so you can check them out there. Today, Teresa and I are going to talk about what's going on pre-legislative session. It feels like a lot already. And then Tom will jump in. We're going to talk about hemp, what's going on with the federal law changing, and then some fraud issues. So, Teresa, you ready to go?
Perfect. Yes. Good morning, everyone. Just to kind of touch base, kind of where we're at. I think the last time we were on was August, I believe. I feel like we are in a constant state of special elections here in Minnesota. And earlier this week, the governor just signaled that we will have two more special elections. The House is currently down 67 to 65 with two retirements. So the Senate had two swearing in ceremonies this week. So the Senate is back at full strength in Minnesota. So we have a 34-33 Democrat majority back again. But that then opened up one seat in the House that they are going to need to fill. And then information that we all are been watching is we had a couple mayoral elections in Minneapolis and St. Paul, and at the last minute, co-chair of the House Commerce Committee, Representative Hurd, decided to run for mayor in St. Paul, and she did win, which means that we now are down a co-chair in Commerce, but we're also down her seat as well. So there will be a special election in Woodbury, and there will be a special election in St. Paul. If there will likely be primaries. So the primaries will be in December and the special election will be in December or in January, which means when session starts on February 17th, we should be, knock on wood, back at full strength. I think they said if you looked at the year so far, I think there's only been maybe 42 days where every seat has been filled. So next year, just to kind of look ahead to next session, it is going to be a quick session. We don't start for another 3 months. We enjoy having a later start when they're not in office and they're not at the Capitol. They can't get in nearly as much trouble. So it'll be a 90-day session from February 17th. Start date till May 18th is when they must adjourn. Next year is a very big election year. So again, if we're looking at what they're going to get done next year, it's probably not going to be a whole lot. On December 4th, the November forecast will come out, which is kind of what they base any supplemental budgets off of, and then they will have another budget. They'll have the budget. The February forecast will come out at the end of February, beginning of March, and then that's kind of the numbers that they'll work on. So whether they have to do some budgeting stuff, that's, normally the second year is a bonding year and a policy year. So that's kind of, again, what we're looking at. But if you really look at, every day, not only are we having special elections, we're also having retirements. The retirements for next year are kind of really adding up, whether it is state senators or House members that are running for higher office. We have quite a few that are running for governor, state auditor, a lot of congressional seats. Again, we talked about Representative Hur leaving the House and Commerce. The Senate Commerce Chair, Matt Klein, is running for the second congressional district. So that's another one that we're watching this year because that will also kind of dictate what he decides to do in the Commerce Committee in the Senate as well. So again, we're looking at a lot of retirements. We're looking at a lot of movement next year. It's 90 days of them wanting to get in and get out and start campaigning. So we have and Tess kind of said we have a lot of stuff that we're looking at for next session, but it's not so much stuff that we personally are proposing. This is the time of the year where everybody starts vetting kind of what bills they want to push next year. The departments are looking at which bills the governor is going to approve for them. And so this is when we have a lot of other lobbyists, a lot of contract lobbyists, a lot of other associations that reach out and let us know what their ideas are. Because again, 90-day session, a 34-33 Senate, and a 67-67 House, will mean that anything that will get passed next year must be on a bipartisan basis. And so they're going to have to get votes on both sides. Otherwise, it's not going to end up happening. I mean, again, we also have the governor who's running for a third term. So again, there's not well, we have a growing list of issues that keep showing up in my email box. How much stuff is actually going to get done next year is going to be very debatable. So I'm going to start running through some of the ideas and some of the legislation and language that has been sent over to us that we're starting to vet. As I kind of as we go through it, Tess will fill in, quite a few of the details of the actual proposal. We are always looking for feedback. So if you have any information, any thoughts on some of the proposals that are being sent to us, want more information, feel free to reach out to us, drop something in the chat. But we, again, would always like feedback. The first one that we're going to talk about is unclaimed property. A couple of years ago, the Department of Commerce dropped on us after the beginning of session a huge change in unclaimed property. And we kind of pushed back on them, and nothing ended up happening that session. We spent a great deal of time in the interim, in working groups, and nothing ever ended up happening. So they are coming back this year with another proposal. We have reached out, and in our conversations with them, I said the earlier you can let us know what you're looking at, the more likely we are to be supportive or helpful. So they have reached out to us. They have given us language, and Tess will kind of fill in some of those details.
Yeah, so on the bright side, one issue with unclaimed property is that dormancy fee is very confusing for banks. You're allowed to charge a dormancy fee for 12 months. Um, they didn't limit it in this bill to 12 months, so it could go for longer. It has to be a reasonable amount. I've not heard of a bank charging something that anyone would consider unreasonable, but um, the biggest issue in there is they don't want safe deposit anymore. They don't want you to send contents to them anymore. They don't want safe deposit as part of unclaimed property at all. Um, this is a big problem. As a lot of you know, if you have safe deposit boxes at your bank, if someone doesn't pay, you've got to drill it, and then you've got to take the contents out. You have a notary there, and you got to do an inventory, and then those contents are sent to the state. So that's how it's done in almost every state in the country. There are a few states that require the bank to liquidate those assets, meaning if you find something that seems to be valuable in there, you would have some sort of auction or sale process. We obviously don't want any part of that. That's what Mississippi has, and they're trying to change back to the way that the law is currently here. So we've let them know in strong terms that this is not going to work for us, and that it's just one more reason for banks not to offer safe deposit. Not usually a profit center for banks, and so hopefully we'll see the changes we need to see there. The other thing is that they weren't counting some electronic transactions as being an evidence that your customer is using the account. Well, that's all we have these days, right? It's almost all electronic transactions, and so we're going to need to have that adjusted too. But if we can get taken care of those things, I think it won't have any impact on us really.
So that is one of the first ones. The next one that we would talk about is the digital asset legislation that the credit unions are looking at. They have a credit union up in St. Cloud that's I think it's from all the articles that are out there, it's the first one, I think, in the States that's really kind of pushing this type of product. And so they are coming forward this year with some legislation. We have had conversations with them asking whether we wanted to be part of their bill and if we needed anything on our side. Obviously, a lot of stuff is happening at the federal level with the Clarity Act and the Genius Act. And I'll let Tess kind of talk a little bit more about kind of their proposal.
Right. So credit unions do not have the same authorities that bank do to custody digital assets. And so we understand that a state chartered credit union would want to get that authority, would probably work for national charters as well. Banks can custody digital assets already. Um, where we're concerned is that that credit union wants to issue its own stablecoin. I think they're going to do it. From the articles, it appears they're going to do it, whether they have the permission to do it or not. But um, the issue in their bill is well, number one, it's hard to understand sometimes what they're trying to do, but they want to handle incoming and outgoing blockchain transfers, convert digital assets to and from fiat currency or currency that's based on, let's say, the dollar, so a stable coin through registered money business partners, and um, and then collateralization of member assets held under a custody relationship. So I guess lending against those assets as well, which there is some authority in federal law for a customer to use digital assets as custody or collateral for a loan. Um, but this goes beyond what we're aware of other states doing. It goes beyond the Genius Act because the Genius Act is just stablecoin. Um, so we do have a lot of questions about that, and our bankers are that we've talked to are concerned about it. They're concerned not only that a credit union might not have the expertise for that, and they will operate through a credit union service organization. I'm sure there are third parties that are working with them as well. Um, but also whether the Department of Commerce itself has the expertise to make sure that this is done in a safe and sound manner. So we do have a lot of concerns. And if there's anyone out there that's an expert on these issues, we'd love to talk to you about it. Such people are few and far between. So yeah. So we'll continue to talk.
We can only chat GPT so much.
True.
After that one, we've had a proposal that has been sent to us by a contract lobbyist for auction.com. And so it's on foreclosures, and it's allowing a qualified private selling officer to conduct foreclosure sales, either online. And so instead of going through the sheriff, and I'll have Tess talk a little bit more about it. But Tess and I have both been around for quite some time, and I keep telling everybody, I'm like, I would really just like a legislative session that we're not looking at foreclosure legislation. It feels like that has been something we've been doing since, 2007. But here we are. Here's another proposal. So, Tess.
Yeah, so this would allow a bank to hire a third party to do their foreclosure sales and also to have those foreclosure sales online. The sheriff's office will still be involved in everything but the actual selling. The hope is that there will be more exposure to the properties for sale that will drive up the price. The bankers we've talked to when they have foreclosures on their portfolio loans, they are usually the only one bidding for it. But we've talked to banks that like this that are already using a third party to do their sales in other states. And so at this point, we don't think it's a problem. But if you have any feedback on that, please let us know.
Yeah. And again, we also not only do we hear from other lobbyists and contract lobbyists and associations, we also hear from legislators. Tess and I um, we had a meeting a couple weeks ago with a legislator who had a constituent um, issue when it came to UTMA accounts. And do you want to go into that one a little bit?
Yeah, it was a sad story. Her husband had died, and he was the custodian on their children's um, Utma accounts. And so she was upset by this. And we know under state law that there can be a successor custodian named, but that didn't happen. But we've heard over the years this is um, not great for couples who want to both be on an account with their child. They both want the convenience of being able to deposit in there or deal with that account. And there are a few states that allow two custodians, so we're looking at that. Um, we think that banks would like it. Again, let us know if you don't, but it would allow two people to operate that account jointly as custodians. And this would answer the legislator and his constituents' problem. Successor is not the same as being joint, obviously, and so this way people don't have to choose who's going to be the primary person on that account.
Yeah, and when we were in that meeting, we had two separate meetings, two different constituent meetings with them as well. The other issue that came up at that meeting, and I think this is one that we are very interested, it's on campaign finance. So when a candidate decides to run for office, they are told to obviously set up a bank account for their campaign, whether it's a campaign account, whether it's a political party account, whether it's a political action committee account. You must go into a bank to set up these accounts. And what we are finding is that there are oftentimes if you really look at how often these accounts are set up, it's very infrequent, and so, if you, and we, just based off of the number of, financial institutions in the state, whether it's banks or credit unions, the number of institutions that really probably understand the inner workings of these accounts is probably, few and far between, because again, you're probably doing one maybe every couple of years. And so the constituent was actually a treasurer for one of the campaign committees and is kind of apparently kind of their go-to person whenever it comes to setting up because she tries to help these candidates go into banks and set up accounts and what the bank's asking for and what they need. And I've done some research on campaign finance website and the campaign finance has a handbook for what they give to candidates and PACs and what they should be bringing into banks. But again, campaign finance, they're not a regulator. They also probably do not understand the way that banks work or what drop downs there are for accounts. And so what we are finding and we're kind of working internally on is to what's the best advice for setting up these accounts when somebody comes into the bank. Tess?
Yeah, one of the problems mentioned was if you set up a campaign account for, let's say, campaign of so-and-so, but the check comes in as, name with a different type of, it's obviously for the same thing, but it isn't titled the exact same way as the account, and having those checks be rejected. You can imagine trying to get another donation from someone with a new check would be probably difficult. So, we'd like to have more guidance. Hopefully, we'll be able to put something together for our banks after getting more feedback from the Campaign Finance Board so that it's more clear. I mean, it's covered in our deposit manual, but it could be a lot better. So we are working on that.
Yeah. Next one that we have on here is the virtual currency kiosks. This was it was two sessions ago, not 25. It was in the 2024 session, I believe it was, that the Department of Commerce actually had a bill on the virtual currency kiosks as they started popping up, literally popping up around the state. And so I think Minnesota was actually probably one of the first ones that kind of really implemented this law. But what we are now seeing is there's many articles that are coming out with a lot of the fraud that's happening with these virtual currency kiosks. And then also cities that are looking to have ordinances to ban them. I believe Stillwater has already banned it. St. Paul is looking at banning them. And whether there is more that can be done at the state level. And we heard a story about, speaking of fraud, it was, whether it was in whatever retail establishment it was in, it was, two elderly women trying to feed $2,000 into the machine. And so at what point is, you're looking at the amount of fraud that is coming with these kiosks. So, Tess?
Yeah, there are some estimates that 90% of these transactions could be fraudulent, which is insane, right? Yeah, we had a comment from someone just now that the amount of fraud they see around these is crazy. Yeah, it's a big problem, and it's great that we have a law, but it just probably is not doing, well, it isn't doing enough. So you have a $2,000 daily limit for new customers, but new customers are like new to that kiosk in the last 72 hours. So it's not the 30 days we have with our bank accounts. It's 72 hours. So the protection doesn't last long, and the refund requirements are only for new customers. They've got those new customers have to contact kiosk operators within 14 days. But, fraudsters are working around these rules. One thing I saw is they're just giving a QR code for this. And so they're able to use that machine, but also then direct it. It goes directly to the fraudster instead of through that kiosk system. And then the kiosk system isn't responsible for any refunds. So that's one way around it. I've heard their fees are as much as 30% of the transaction, the kiosk operators. So that's crazy. One comment, as someone who works in compliance BSA world, I can say that I have never ever seen a transaction from a virtual currency kiosk that has turned out to be legitimate. Yeah, and that's why we're seeing cities that are banning or considering banning. We have Stillwater that banned these kiosks. St. Paul banned them. Brooklyn Park's looking at it. Forest Lake, Hastings, Cottage Grove, Woodbury, probably many others will just ban those in their cities because there really isn't a legitimate use case for these. People who are dealing in digital assets are generally more sophisticated investors, and they have a different way to do it. They don't have to put cash into a machine at a gas station. So um, I think there will be some effort this year at the legislature, hopefully to tighten this up a little. Maybe the new customer definition can be changed. Refund requirements applying to everyone, things that will make it less attractive to fraudsters to be operating in Minnesota, I guess would be our goal here. Um,
And the crypto lobbyists are going to come out in force because apparently they've got money from somewhere, these kiosks maybe. But it'll be interesting to kind of watch as they, because they're threatening to have lawsuits in these cities that are banning them. But I know that St. Paul, um, when they were bringing their ordinance, they felt that they were on solid ground, that they were not too concerned about the lawsuits coming from these kiosks.
right. I mean, they do have the consumer protection angle, which is it's will be strong in court. Um, they don't have a lot of losses reported in St. Paul yet. Teresa gave me some stats from the state about losses that they know about, right? So this is just what they know about, but we've got 718,000 in reported losses in Minnesota overall. I'm sure it's a lot more than that, but that's what the state has received reports about, and only 92,000 in refunds. So obviously just a fraction, just over 10% have even been refunded. So these kiosks are a big problem, and we will be looking at it this year to see if there's ways we can tighten these up so they're less attractive. To all fraudsters. Tom, do you have anything
Well,
on that? Sorry to put you on the spot, but um,
Yeah,
he doesn't.
there we go.
Okay.
My unmutes weren't working there. Um,
Are you hearing anything from banks on this, Tom?
I I haven't too much. Just I haven't heard from bankers. I mean, other than that, probably anything that I've heard probably mirrors the comment. Just they haven't seen anything that hasn't been fraud related. It hasn't been as active as say people going to get cash out and going to Walmart or something and getting a bunch of gift cards. That still is a popular scam, but the virtual currency is another way to do it, certainly.
Okay. Yeah, so any feedback on that issue that you have for us? We've heard from others that this is going to be something that people would like to look at this year during the legislative session, so hopefully that's the case.
And then Tess, the last one I had before we hand it over to you and Tom on hemp is the trusted third party idea.
Okay, so this is something that we are looking at doing proactively is um, Missouri has a new statute that allows a bank to contact a third person that's been appointed by the customer. So the idea would be at account opening, or, if this passes, you can do it with your existing customers. But if they want to appoint a person that you can contact or the bank can contact if they suspect fraud, accounts gone dormant, even things like that. Great liability protection in the language that we would propose. Banks are doing this already, and so the idea would be that we get this in statute to protect banks that have it in their account agreements already. So
And we already have it
anything
on the
but
books for 45A, right?
right. So this would go for not just for vulnerable adults or seniors. It would be everyone. So you could do it with any customer. I think that's it on that one. So
Yep. And that's all.
hemp, Tom, hemp, this is a big issue. Minnesota's got a big hemp industry, and do you want to talk about what's happened? What's
Right. So,
destroying their world? Yeah.
right. So part of the shutdown bill, funding bill to get back, appropriations bill to get back on there, what they went in and they changed the federal definition of what qualifies as hemp. So that just the big benefit of that is anything that's hemp is not considered marijuana federally, so you could do more with it. And the big changes to the definition that impact the Minnesota businesses and banks are that they remove the limitation on just talking about Delta 9 THC. So now it's any THC. And kind of with that change, they added in any cannabinoids. So anything that can be derived from the plant directly or synthesized from chemically from the plant. Any kind of cannabinoid from that is now covered by the hemp limitation, so still has the 0.3 percent based on dry weight. And then the other big piece that'll impact the Minnesota businesses is limiting the final retail packaging to having no more than 0.4 milligrams of total cannabinoids per package, which is it's quite small. Um, and so that's going to be the big impact on that. If nothing changes to this law, how it is right now, any of those currently uh, hemp products that are sold in Minnesota will then become federally marijuana upon the effective date, which is not until November 12th of 2026. So there is some time and potential for maybe a federal fix. The state can't do much. I mean, they could conform their packaging requirements to still keep products within the hemp definition federally, but it's pretty small amount, so it may not be something that they wish to do. But yeah.
Right.
So
So
if you
that
have
that
yes,
new definition is so zero point 0.4 milligrams of total THC, right? Anything more than that really is cannabis, right?
yep,
And it's
anything
going to
more than that
fall.
is considered marijuana, right?
Yeah,
So that's what
and
I'm
that
saying. If
is not much, right? That
it's
is
not
not,
much, no.
it's not much. You couldn't make a drink out of that that would have any kind of effect on anyone. I mean, it's not going to be a marketable product. And so these people that have the hemp businesses, some are thinking about getting their medical, or not medical, but their adult use license to be able to continue to sell their products. But as Tom said, this is a long runway. So somebody asked about what are they supposed to do with their current inventory? Well, they have at least until, what did you say, Tom?
Yeah, November of next year. It's
November
1 year
2026.
from the
So
effective date, so or 1 year from the signature date.
yeah, then they could get their state license to sell adult use cannabis. I think that's costly and more complicated than what they've had to deal with. The Office of Cannabis Management is looking at this closely to see
Yeah.
what they can do to help these companies. But yeah, this is a sea change. I mean, this is a really big deal.
Yeah.
And it's
And
possible that changes could be made in Congress. The idea was that this was when the Farm Bill passed and exempted this hemp, that it was a loophole, that it wasn't something that they realized they were voting for when they passed the Farm Bill in 2018. So that's how this came about. That I think it was Mitch McConnell who wanted this taken out. So there will be a great amount of lobbying. It's already going on. I assume that our congressional delegation is going to support um, hemp businesses continuing to operate as they have been, but we'll see. I mean, everything is difficult in Congress, so it's hard to say.
Yeah, if nothing changes with the federal law, then still selling those what are currently considered hemp products in Minnesota, those would be marijuana products. So then you got the SAR filing triggers for those. That activity occurs. So as soon as the effective date happens and nothing else changes, you'd be on the clock for filing your SAR if you have those business customers selling those, what are now
Right.
hemp products that would then
Yeah.
be marijuana products. So
And a lot of
it
banks
could be a
haven't wanted to be
mess.
in that business, right?
Right, right. And it may be an unintended consequence that could be a good thing to point forward because I don't think FinCEN would want the deluge of marijuana filings, SAR
Yeah.
filings in November of next year, because there would be a lot.
Yeah. 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 This is a big deal. So we will keep everyone updated in our legal compliance bulletins on what's going on. But um, yeah, there's a lot of unknowns right now. Hopefully, Congress will do something, but hard to say.
Yeah, hard to say what they're gonna do. Yeah,
Yeah.
we'll probably
So
hear a lot about it though over the next few months.
we will. Yeah. Yeah. There won't be any shortage of news. So we also wanted to talk about a little bit about fraud. Tom had some, what did you have? ACH was one thing you wanted to mention.
Yeah, one thing, so NACHA has updated their rules, and one of the big things that's coming out in March of 2026 is fraud monitoring for all originating depository financial institutions. So if you have any originators at your bank, by March 2026, March 20th of 2026, you'll have to have some monitoring in place. And it don't really anticipate it being that huge a lift for most banks. It kind of depends. They want you to have risk-based procedures, policies, and procedures around that fraud monitoring. But they're not requiring live 100% monitoring of every entry that goes through your institution. So it's not something where you necessarily have to do, uh, check every entry before it's sent or anything like that. You just need to have the capability to identify when your originated customers have atypical activity. So first you need to identify what their usual activity is, and then you need to have procedures in place so you can identify when something unusual happens, like, if they only do payroll, and all of a sudden their payroll jumps from 20 people to 60 people, that would be a red flag, what's going on. Have they really hired 40 more people? Or there's something untoward going on to that. So that kind of thing. And then kind of tied to that, there's fraud monitoring that's also going to be in place for those receiving depository institutions on ACH credits. Uh, and that's kind of a two-step implementation. You've got March 20th to 26th for the largest institutions, and then July 22nd of 2026 for the smaller institutions. And again, it's the same framework. You don't have to monitor every single entry that's coming in, but you need to be able to identify any of those atypical entries that are coming in. Um, and then as well as part of that, with your kind of fraud monitoring, you need to lay out how the bank is going to respond. So if you do identify some atypical activity, if it's with an originator, are you going to contact the originator? Are you going to stop processing for that originator? What steps are you going to take once you've identified that atypical activity? And two, if there's any other internal resources that you need to contact. If your ACH function is separate from your BSA function, you may want to have conversations between there. If fraud is a separate function from those. All those sorts of discussions need to be kind of covered too with your fraud monitoring program. Kind of some of the on the receiving side, when you're getting credits, particularly on the consumer side, you want to check things you would check for would be things like incorrect SEC codes. If you have a consumer account and there's commercial credits coming in, that could be a red flag. But then other some big ones are just changes in volume, frequency, and amounts. If all of a sudden, the amounts on ACH credits coming in go from $20 to $2,000, that can be a concern. Or if they, normally your consumer has or your customer has one or two a day and it goes up to 20 a day, any sort of big changes like that can be things that you'd want to be able to capture in your monitoring and then investigate whether it's something that needs to be looked at further or the bank needs to take some direct action on. So those are some new things that Nacho is uh, doing on that in
Or
2026.
requiring others to do, huh?
Yeah, requiring others to do. Yep, that's part of yours.
Do you think this is
So
something that a lot of banks are doing already, or does this feel
I
new?
yeah, I think some of it banks are already doing already, especially on the originator side. I mean, you're already required to look and make sure if there's so many returns and things like that with your originators and what's causing that and make sure that they've got proper authorization and things of that nature. But um, from what I've seen, at least a lot of the banks, you're relying on your vendor. Your vendor has a lot of reporting and monitoring capabilities typically in those, so it shouldn't be. I don't expect it to be an enormous lift for banks, but it may just be something where you kind of you have to have a policy in place should NACHA or someone else request it to make sure you've got those policies and procedures in place and what you're doing. But it may just be documenting what you already do.
So we should probably put out a bulletin about this, Tom. It feels like a
Yeah,
lot.
we can do that.
Okay. So look
Umatcha
for
is a good
that.
resource too if you're a member of Umatcha.
Yeah. Did you want to talk about that counterfeit versus altered checks topic?
Yeah, it's just kind of briefly, there's been a number of questions where banks are asking what's the kind of the liability differences for banks when they experience altered and counterfeit checks. So if it's your customer that's experiencing an altered check or counterfeit check, who bears the liability? Uh, and kind of first off, for either of those, as long as the customer notifies you within the time frame you've imposed in your deposit agreement, or if you're not specifying a sooner notice requirement in your deposit agreement, then it's going to be covered by the UCC, which provides years in some cases. But so as long as they provide that notice adequately, the customer is not going to be liable for those checks because they're not properly payable items for the customer. Now, there's no set time frame on when you have to reimburse the customer, but it's kind of a reasonableness standard. So you want to do that. But as far as between banks, the general rule of thumb is if you have an altered check, the depository check, you're um, the drawee bank or the paying bank of the item. Uh, you have a breach of warranty claim with that other bank because the item has been altered and they provide a warranty that it hasn't been altered. So you can go after those steps directly with the other bank or possibly through the clearinghouse if you have that relationship. But on a counterfeit check, it's typically going to be on your bank if it's your customer that suffers a counterfeit check. The liability because there are some exceptions there, but that's the general rule. And kind of the big difference between the two, if you have an altered check, it's typically going to be an original item from the customer, one of their checks, whether it's stolen from a mailbox or stolen from, the accountant, whatever. That's going to be an altered check. But if it's a wholly newly created item, that's going to be a counterfeit item. So you get a lot of questions on, well, obviously, if it's your customer, you want it to be an altered item because then you have more liability protections than if it's counterfeit. But so that's kind of the initial hurdle there.
We have a question for a counterfeit check. Does the reasonable notification still apply?
Yeah, they still have to notify you if you've got limitations, and typically that's going to be in your deposit agreement, where a bank will limit it to usually 69 to 90 days from the time when the item appears on the statement. So if you have that in the deposit agreement, that's still gonna control that. Um, You
I
know, in
think
a
we have a
big,
court case, Tom, that shortens that quite a bit. Like that found that a bank that shortened it, it was 3 weeks, something like that, right? Like 21 days or something. That was
Mhm.
still reasonable. And so, I mean, when you're going 60 days or 90 days, that's probably a lot more than you need to be doing.
Yeah. And too, if you have positive pay or things like that, particularly in the commercial space, you can impose that on your commercial customers and say, look, we have this good tool that can help prevent these sorts of fraud items. And if you don't sign up, and we can show that this tool would have prevented the fraudulent item from going through, then you can, shift that liability onto that commercial customer as well. So
Yeah, so this
kind
all
of the
comes out of the
benefit,
Uniform Commercial Code, right? And so
right?
long time ago they decided to separate the liability, a depository bank taking the altered check because they should know what the checks look like when they're deposited. They get to look at it, right? So
Right.
they're supposed to be in the best position to notice if something's been altered. And then on the other side, with a counterfeit, you know what your customer's check looks like. So the dry bank's going to be responsible for that. I mean, you know what your customer's signature should look like, right? I mean, theoretically, all of this is theoretic. So
Yes.
I was talking to one of the UCC commissioners a couple of weeks ago, and they said that they are looking at this again, like if there's more they can do in their laws on this fraud issue. So it's possible we'll see something, but they never move that fast. So it'll be
Right.
years before anything changes. But at least somebody's looking at it to see, does this balance make sense still? It'll be good to have an outside group look at that. One of the things to think about is there's some tools that ABA has. They
Yeah.
have that registry of fraud professionals. So hopefully that a bank is signed up for that, and then you can go and see who their fraud contact is. You don't have to be a member of ABA to do this, but you
But you
need to
do have
put,
to register,
yeah,
right?
yeah.
You have to
You
register
can't just
yourself
look.
and put your own
Yeah,
contact info in. Right.
yeah, and then you'd be able to hopefully have a good contact, which is always a big issue. They also have a treasury check verification system too that you can use so that you can put them in and make sure that it's valid and not
Right, and
counterfeit.
it gives it's more they've got the publicly facing one that doesn't allow what is it the payee information is the big difference where you can verify payee in the ABA's a joint system with Treasury. So
We had a question. How would you go about shifting the liability to the commercial customer if they refuse positive pay without having them sign away their rights?
yeah, it just have to be a contractual agreement. Yeah.
Yeah,
So
there's case law on this. I mean, good case law for banks. Banks generally win. That sounds like another good bulletin. I can
yeah,
write this one, Tom.
and what are the, yeah, especially if you have a law firm is the customer and they're having check fraud issues, they're deemed to be like super experts. So
Ooh,
the courts really disfavor them as customers as opposed to banks because they say, well, you should really know what's going on because this is your
yeah,
area. So
yeah, yeah. We'll take a look at that. We get a lot of questions about the positive pay issue, so we should put something out about that.
yeah, then you probably want to go seek out your own counsel when you're developing a form
Hmm.
like that
Yeah.
to shift liability between you and your customers. So
Yeah, we can just give you some case law that's out there, what courts have held on this issue, and a little bit about the fact situation, so you have a better idea before you talk to your bank's attorney about it. Anything else, Tom?
that was all I had, I think.
Okay. Here's something. Anything on the new Minnesota Statute 609.2334 that takes effect January 1st. New order for protection against financial exploitation complements 45A. And then someone asked about that case info on positive pay. I'm going to put together a bulletin on that. I think a lot of people would be interested in that. So
Yeah,
um,
so
let's see. This statute's not ringing a bell. You, Tom?
yeah, no.
609.2334.
I mean, that's a criminal statute, obviously.
right? Yeah. Um,
And I believe that one came up last year. That's really jogged my memory. Um, I remember it
okay.
coming, I remember, and we were watching that bill.
Okay, so
So just if so,
oh, okay. A petitioner may petition the court for an order for protection against financial exploitation of a vulnerable adult seeking injunctive relief and any other equitable remedy the court deems appropriate. Oh, okay. Yeah, I remember it now, Teresa, a little bit, but um, I haven't heard anything more about it, but it's a way to an additional way to protect seniors. So someone could step in, in one of these situations where they don't believe they're engaged in a fraud, you know, and get the court involved. Um, so, hmm. I guess that one deserves a bulletin too.
yeah, all sorts
Something
of
else
tasks
here.
taken away.
Some vendors have language in their T&Cs placing liability on the customer for fraud if the bank offers a service such as positive pay and the customer refuses to use it. The liability falls to the customer. Yeah, that's what we saw in these court cases. And you always question whether the court's going to uphold a contract like that, and they have in many instances. So that's what we'll cover um, in a bulletin. Yeah.
Yeah,
Is that it? I think that's it.
I think
Um,
that's it.
wait, no. Do you feel that we need to change anything in policy in regards to hemp? Not banking at this point, or do we just wait and see if any more changes come? I think our issue is that this is a federal law, and so, we can change our packaging rules, for example, but if they're going to be selling something that has any impact, it will be considered cannabis, right? It's marijuana,
Mhm.
not a hemp product anymore. So, yeah, I think they could look at the packaging, but it's going to be for marijuana. So I don't know. We will see more. This is the Office of Cannabis Management. I mean, Minnesota just set up this whole thing, right? It's invested a lot of money and time into this industry, and so they will be working to see how we can work best within the federal framework, but also try to change. There's not a lot that can be done if it's considered cannabis under federal law.
Yeah, and if banks have in their policy, which I think many do, that they'll bank hemp customers but not cannabis customers, if there's no changes to that, November of next year, all those currently hemp customers become cannabis customers, and if you're going to separate them from the bank as clients, I mean, you certainly there's going to be some, potential changes, regardless, either to your own policy and procedures or not. So,
Yeah.
Well, and that also is going to it's going to change where they can sell those products as well. So, right, so the breweries, they can't sell them at where they're currently selling them also. So it's a bigger.
Yeah. Yeah.
right.
It's a huge, huge issue.
There was a,
Go ahead.
comment in there about the account closure for unruly customers and whether that passed, and that did pass. So it was effective August 1st. Is that right? I think.
Yeah, so that's 47.77, that law that requires you to give 30 days notice before closing an account. You can do it the same day if they were engaged in fraud, if you had a reasonable suspicion of that. But we added, if you have a customer that is harassing bank employees or other customers, you can close the account same day. So yeah, that is effective. Okay, that looks like it's it. Thank you so much for joining us today. Remember, you can just watch this all over again on our YouTube channel for
Yep.
fun. I hope you have a great day. Bye.
Bye bye.